We used to talk to her when she was one of our favourite senators, but now Amanda Stoker is one of us, host of Sunday with Stoker, 7 o'clock here on Sky News. She joins me from Brisbane. Great to see you again, Amanda. What I want to do is, you and I had a bit of an argument about The Voice going back, I don't know, 3 or 4 weeks, might have been longer. But one of the no campaigns is using a bit of that in their advertising. So I thought we should remind people about that and continue the discussion. Here's what the Fair Australia campaign are running. But you just said that a minister must hear representations. It doesn't say that. It says the body can make representations. There's no obligation on a government to seek representations.
Yeah, but if you let me finish, if the body has made representations, they must be taken into account. And if they are not, then that minister will fail to have had regard to a relevant consideration in the making of their decision for the purposes of administrative law.
Yes, and then you did finish, Amanda, you went on to explain how this could be bounced around before courts here and back if they didn't think the ministers had listened sufficiently to the voice, therefore delaying government decisions. Do you think that's the worst case scenario if there are any legal ramifications from the voice?
Look, I don't think that's a small problem if that's what eventuates. There's the potential for other legal consequences as well, as the High Court interprets the words that are used according to their understanding at the time, which isn't always what's contemplated at the time the political discussions are having. But I don't think we should dismiss how significant a problem it will be for this country if we find that we aren't able to have a situation where a decision is made by a minister and those who are depending on that decision are able to reach the point where they can depend on it as being final for the purposes of investment and making subsequent decisions about hiring people and getting jobs off the ground. If we can't get certainty in a commercial sense from final and dependable government decisions in a reasonable enough time frame, then the kind of investment that makes a big difference to whether or not an Indigenous person can get a great job in a remote place just goes to other parts of the world. Yep. It's a real commercial concern and it is a real likelihood as a consequence of the voice. But
the point is about this, before that would happen, there'd have to be the legislation which would frame how the voice would make representations to government. Then someone's got to take issue with that and win a court case or win an appeal and take it to the High Court. And all of that, of course, it could possibly happen. Every law is going to be tested through the courts eventually. But the thing I keep coming back to is, in the end, all the government is obliged to do is listen. So it can never overturn a decision. It can just say that the government hasn't listened properly and they must listen again. There's never an onus on the government to change the decision. I'll just put up the wording here from the constitutional amendment that we're all voting on. And it says very clear there, the voice may make representations. So the sort of scenario you're portraying is just that we might delay things if possible to make sure the government proves it has actually listened to those representations.
I'm so glad you raised this, Chris, because it points out two really important things. First, that the voice that's proposed may make representations. They're not forced to, they might decide not to. On that point, you are absolutely right. They may decide that on a particular environmental or development decision, they don't have an interest and they don't want to talk about it. Fine, not an issue. They may also decide that they do want to have a say on things well beyond what was contemplated. For instance, they may want to have a say on matters of defence. They may want to have a say on matters relating to the economy. They may want to have a say on things that go well beyond what we might think of as narrowly Indigenous issues. But the more concerning thing about the wording that you've just popped up on the screen, I believe, is that at no point are the words advisory only or something like that used.
Yeah, well,
this body is actually not clearly advisory.
Well, it is.
It is well within the scope of a High Court to take it another way.
Well, I've been through that with constitutional experts, and they chose may make representations because it's less onerous than advisory. People think advisory, experts say advisory might suggest that the government must do it or take heed of it, whereas make representations makes it clear that the government has no obligation to do what the voice says. In fact, here's the former Chief Justice of the New South Wales Supreme Court, Tom Bathurst, on that very point.
This body, which is, for want of a better word, enshrined in the Constitution, giving it the power to make representations which, as far as Parliament's concerned, can be accepted, rejected or ignored.
Accepted, rejected or ignored. Very quickly, because we've got 30 seconds to go. Sorry, Amanda.
Really important. The right to make representations is a different question entirely to the question of whether they must be listened to. You're right on whether they may make them, you're wrong on whether or not they must be listened to. The wording does not clarify with any kind of specificity whether or not they must be taken into account. So the default administrative law position is you must take into account all relevant considerations. Nothing that's been said by the experts you've cited gets around that.
Thanks for joining us, Amanda. Amanda Stoker there. Catch her on Sunday night. I go with Tom Bathurst there. It says the government can ignore any representations.